Hey everyone, this is Aditi and you're watching Legal Bites. Our today's topic of discussion is medical and professional negligence. In this video, I'll be looking at the introduction, meaning of medical and professional negligence, what are the essentials of medical and professional negligence, followed by standard of care, then tests to rely on medical negligence, followed by proof of negligence, and at last but not the least, liability. Now let's start our video. Coming to our first topic, that is introduction. Negligence is a civil wrong which occurs from the breach of duty which a person owes to another and due to which the another person suffers loss or injury. Now coming to the meaning of medical negligence. Medical negligence can be defined as the negligent, improper and unskilled treatment of a patient by a healthcare professional. Medical negligence is basically the misconduct by a medical practitioner or doctor by not providing enough care, resulting in the breach of their duties and thus harming the patients which are their consumers. In the case of Kushum Sarma versus Batra Hospital, the Supreme Court held that a doctor often adopts a procedure which involves higher element of risk, but in doing so, he honestly believes that it will provide greater success for the patient. If a doctor has taken a higher element of risk to redeem the patient out of his or her sufferings and it does not yield the desired result, this may not amount to medical negligence. In the case of Jashbir Kaur versus State of Punjab, the court held that the hospital authorities were negligent and had not taken due care and precautions and thus held liable amounting to compensation rupees 1 lakh. Now coming to the elements of medical negligence. The first element is the defendant owed a duty of care to the plaintiff. The second essential is the defendant made a breach to that duty. And the third essential is the plaintiff suffered damages as a consequence to that breach. A doctor owes certain duties of care to his patients. The first duty is it is his duty to decide whether he wants to undertake the case or not. It is his duty to decide what treatment to give and how to administer the treatment. If a doctor fails to perform the aforesaid duties, it results in the breach of duty and gives the right of action to the patient. The breach of duty is committed by a doctor when he does not perform the degree of care like a reasonable doctor. Now coming to our next topic, that is standard of care. A standard of care specifies appropriate treatment and medication procedure given to a patient while keeping in mind his conditions. The care should not be of the highest degree nor the lowest. Here the degree means the level of care an ordinary healthcare professional with the same experience and training would render in the same circumstances. And in doing so, if a person suffers injury as a result of poor treatment, he may file a suit for medical malpractice. In the case of Dr. Lakshman Balkrishna Joshi versus Dr. Trimbak Bapu Godbole, the Supreme Court has held that a doctor has certain aforesaid duties and a breach of the duty can make him liable for medical negligence. Now coming to the test to rely on the medical negligence. Our first case is the Bollam test and the second case is Bolitho test. Now what is Bollam test? The famous case of Bollam versus Freer Hospital Management Company was concerned with a patient having depression and had voluntarily admitted to the defendant's hospital to undergo electroconvulsive therapy (ECT). ECT was delivered to him without any muscle relaxant drugs and he was restrained apart from the presence of the nursing staff to prevent him from falling off the bed. During his treatment, he suffered some violent muscle spasms causing him to fracture both hips. He pursued a claim firstly on the ground that had he been warned of the risk, he would not have undergone the treatment, and secondly on the ground that had he received the muscle relaxant drugs, the injuries would not have occurred. The defense was maintained that there was no requirement to explain the risk involved in the treatment unless specifically asked by the patient. It was held that a doctor was not guilty of negligence if he has acted in accordance with the practice as accepted by a body of medicals. The jury found for the defendant on both the issues, consent and treatment, and in doing so, the Bollam test emerged as a legal benchmark, placing the burden of proof on the claimant to demonstrate that no responsible body of professional opinion would have endorsed the particular course of action, be it the disclosure of risk or the method of treatment. Now, talking about Indian cases where the Bollam tests are being followed. The first case is Poonam Verma versus Ashwin Patel. What happened in this case was a doctor was registered as a medical practitioner and he was entitled to practice in homeopathy only, yet he prescribed an allopathic medicine to the patient. As a result of this, the patient died. The doctor was held to be negligent and liable to compensate the wife of the deceased for the death of her husband. In the case of State of Haryana versus Srimati Santara, Bollam test has been approved. This case too refers to liability for compensation under civil law for failure of sterilization operation performed by a surgeon. In the case of Dr. Suresh Gupta versus Government of NCT of Delhi, it was held that the test for determining medical negligence as laid down in Bollam test holds good in its applicability in India. Now coming to our next test, that is Bolitho test. The Bolitho test has been mentioned in the Indian Supreme Court on only two occasions. It was mentioned in the case of Samira Kohli versus Prabha, where the court clearly stated that a new beginning has been made in the case of Bolitho versus City and Hackney Health Authority. Now coming to our leading case law, Bolitho versus City and Hackney Health Authority. What happened in this case was a child was brought to a hospital suffering from breathing abnormalities. The doctor summoned to take this matter never received the summon due to low battery on her bleep. The child died as a result. The child's mother sued for negligence and argued that the child should have been seen and intubated. The doctor testified that they would not have intubated the patient even if they had attended, and an expert witness agreed this was proper. The issue in this case is whether this satisfied the Bollam test and causation was established. The House of Lords clarified the Bollam test to include a proviso that the practice accepted as proper by a responsible body of professionals must be based on logical and defensible grounds, and in this case intubating the child was not illogical, so there was no breach. Coming to our next topic, that is why Bolitho test should be adopted. Unfortunately, medical negligence occurs every day in the Indian hospital, so the Bolitho test makes it easier to get quick relief as it increases the burden on the medical practitioner and thus leaves more scope for compensation. Now coming to the meaning of professional negligence. Professional negligence is a type of negligence that occurs between the professional service industry worker or company and the respective client. The concept of negligence stays the same. However, in this case, the term care relates to how you are handling or mishandling your client and the respective contract. Professional negligence occurs when a professional is negligent in performing the responsibility to a required standard. Now coming to the essential elements of professional negligence. The first element is duty of care. A duty of care is a moral or legal obligation that ensures the safety or well-being of others. The second essential is the duty must be towards the plaintiff. The duty arises when the law recognizes the relationship between the defendant and the plaintiff and requires the defendant to act in a certain manner to the plaintiff. The case of Dongi versus Stevenson has evolved the principle that we each have a duty of care to our neighbor and someone we could reasonably expect to be affected by our acts or omissions. In this case, it was held that despite no contract existed between the manufacturer and the person suffering the damage, but an action for negligence could succeed since the plaintiff was successful in her claim that she was entitled to a duty of care even though the goods, that is, a bottle of ginger beer with a snail in it, was not bought by herself but by her friend. Our next essential is breach of duty. Breach of duty occurs if the professional's assistance didn't reach to a reasonable level for someone in their position. Our next essential is loss suffered. The loss suffered as a result of professional negligence may be in the form of loss of health or financial loss. Now coming to our next topic, that is proof of negligence. The initial burden of making a prima facie case against the defendant is on the plaintiff, but once the onus is discharged, it will be for the defendant to prove that the incident was a result of an inevitable accident or contributory negligence on the part of the plaintiff. Now coming to our next topic, that is liability. Liability is of three types: civil liability, criminal liability and other liability. Now what does civil liability means? Civil liability includes claim for damages usually in the form of compensation. If there is any breach of duty of care while operating or while a patient is under the supervision of the hospital or the medical health care professional, then the patient is liable to be compensated. Now coming to our next type of liability, criminal liability. There may be an occasion when the patient has died after treatment and a criminal case is filed under section 304A of the Indian Penal Code for allegedly causing death by rash or negligent act. According to section 304A of the Indian Penal Code, whoever causes the death of any person by rash or negligent act not amounting to culpable homicide shall be punished with an imprisonment for 2 years or by fine or both. Now coming to our next type of liability, that is other liability. Further, in the case of Dr. Suresh Gupta, the Supreme Court held that whenever a patient dies due to the negligent act of the doctor will be held liable. Indian Penal Code sections 52, 80, 81, 83, 88, 90, 91, 92, section 304A, 337 and 338 contains the law of medical malpractice in India. The conduct of medical malpractice was brought under the Consumer Protection Act due to the landmark case of Indian Medical Association versus VP Shanta and others. The judgment in this case referred the term medical care as services, and the person seeking medical attention may be considered as consumers if certain criteria are met. The first criteria is the service provided should be free of charge. The second criteria is if free, the service provided is waived of the charges because of the patient's inability to pay. The third criteria is the service provided was at the private hospital that charges all patients. The fourth criteria is any service rendered which was paid by an insurance firm. Hey everyone, if you find this video useful, do like, share and comment. We'll meet with the next video very soon. Till then, bye bye. Thank you.